You're watching The Legal Breakdown. Glenn, something that I think we all expected to happen here is that we now have news that the DOJ is moving to wind down Donald Trump's criminal cases. That is, of course, the two cases that the DOJ is overseeing. It's the D.C. prosecution related to all things electoral certification blocking on January 6th, and also the classified documents case, which is right now pending in the 11th Circuit Court of Appeals. Is this surprising? Is this advisable? What's your take on this move by the DOJ? Is it disappointing?
Yeah, Brian. So the reporting is that Jack Smith is, quote, winding down the two federal criminal prosecutions of Donald Trump. You know, just the other day, we were talking about and did a video about how we fully expected Donald Trump to dismiss his own criminal cases once he took office, or more precisely, direct his inevitably corrupt Attorney General, whom he appoints, to dismiss his charges. And it looks like Donald Trump may not even be forced to engage in that corruption. Because if Jack Smith is winding down those prosecutions, what does that mean? So let's talk about the consequences of winding down his criminal cases versus potentially gearing up his federal criminal cases. First of all, the reason Jack Smith would be winding down the cases is because of this policy memo. It's called the Office of Legal Counsel memo, the OLC memo. It is a horrific position for the Department of Justice to take, but they've taken it for years. And that is that we can't criminally prosecute a sitting president. So a sitting president gets to commit all the crimes he wants in violation of our nation's laws against the American people, and he can't be prosecuted for them while he's in office. Now, mind you, Brian, that's just a policy memo. It's not the law. There is no court precedent, and there's nothing in the Constitution that provides you can't prosecute a sitting criminal president. But the whiz kids at the Department of Justice, Office of Legal Counsel, said, no, we don't think it's a good idea for you to be able to prosecute who? Our boss, because the President of the United States is the boss over the Department of Justice. So it makes some intellectual sense that if Jack Smith is bound by that memo, his prosecutions of Donald Trump cannot proceed while Donald Trump is president. But what does that mean, Brian? What does it mean if Jack Smith voluntarily winds down and presumably dismisses Donald Trump's federal cases? Well, here's what it means. It means that the Department of Justice will not be forcing Donald Trump's hand to engage in corruption and possible further criminal activity by ordering his Attorney General to dismiss the criminal cases against him. It will actually be Jack Smith doing an enormous benefit to Donald Trump because he won't be forced to, nefariously and perhaps unlawfully dismiss his own criminal cases. So I am hopeful that Jack Smith and his team are taking all of that into consideration and trying to decide if it's the right thing to do, abiding by that Office of Legal Counsel memo saying we can't prosecute Trump once he's sworn in on January 20th, or should he force the issue on Donald Trump and make Donald Trump act corruptly by dismissing his own cases? I would vote for the latter approach because otherwise it's a windfall to Donald Trump. Here's the really important thing about the winding down scenario. Special counsel is authorized to issue a report. So Jack Smith is probably working on a report right now in which he will detail lots and lots and lots of what he's learned about the crimes of Donald Trump. And let's be clear, we all saw a Jack Smith court filing not too long ago that detailed some of Donald Trump's crimes and the evidence of those crimes. However, Jack Smith only put in that court filing what he needed to, the evidence that he needed to present to Judge Chutkan so she could litigate the presidential immunity issue. So that is probably a much more precise, limited, and narrow document than a special counsel report would be. Remember the Mueller report, hundreds and hundreds and hundreds of pages about Russian interference and about Donald Trump's obstruction of justice in connection with firing Comey and engaging in all other kind of criminal activities, something for which Donald Trump has never been held accountable. But think, special counsel report is a tome. It's going to be a very large, weighty narrative about the the crimes of Donald Trump. So Jack Smith, if he's winding down the prosecution, he may be gearing up for issuing his special counsel report, because what we can all expect is the minute Donald Trump is sworn in, Donald Trump's words were he will fire Jack Smith in, quote, 2 seconds. So I do think one way or another, Jack Smith's days are numbered.
So basically at this point, Jack Smith can choose not to release the report against Donald Trump, and then that means it'll go away forever. Because if Jack Smith doesn't release it, we can be sure as hell that Donald Trump's own DOJ won't release a report condemning him and exposing his criminal behavior. And so at this point, it's pretty much put up or shut up with Jack Smith and this report.
Agreed, Brian. And let's take on one more piece of the winding down scenario. While Jack Smith may be winding down his criminal prosecutions and drafting or gearing up his special counsel report, he doesn't necessarily have to dismiss the case at the end of the wind down of Donald Trump's criminal cases. What do I mean by that? He could go to Judge Chutkan and say, listen, Your Honor, we understand and will abide by the Office of Legal Counsel memo that says we have to suspend this prosecution or these prosecutions after Donald Trump is sworn in. But that doesn't mean we necessarily have to dismiss the case. Let's just put a stay on the case, keep it in existence, and then it can commence as soon as Donald Trump leaves office. So I'm not suggesting that will happen, but I don't want to leap to the conclusion that the only thing that can be done at the end of the winding down period is an outright dismissal of the cases. And here is the other thing that is like gnawing at the sort of back of my mind as a former career prosecutor. If the winding down period concludes with Jack Smith dismissing the cases against Donald Trump, well, then in 4 years, assuming Donald Trump leaves office, the statute of limitations, that's a fancy way of saying if you don't bring a case within 5 years, then the case goes away and it can never be brought. That's the statute of limitations precluding a prosecution. The statute of limitations would expire and Donald Trump could never be held accountable. Not so if Donald Trump is forced to engage in corruption to dismiss his own cases, which is the thing I voted for a few minutes ago. All of this, there are a lot of moving pieces, nothing is certain, and there is no clear reporting. But can we shift over to how Jack Smith might be gearing up in some prosecutions?
If we can put a pin in that point for a sec, just a quick question. So right now, basically, Jack Smith has the opportunity to himself dismiss this case, and that would prevent the DOJ from taking up the case again in 5 years when hopefully Donald Trump is out. Is that what we're saying here? As opposed to Donald Trump working unto himself and working with his own attorney general to dismiss the case corruptly, that would allow the DOJ to bring up this case again down the line.
I am saying that, and let me put it in sort of a more easily understood hypothetical. Let's assume somebody gets indicted, and before they go to trial, they flee to avoid prosecution, and they stay away for 6 years. But the statute of limitations on their crime is 5 years. So if the prosecution doesn't commence, doesn't begin within 5 years, then the statute of limitations bars or prohibits that prosecution. However, if somebody flees, well, the reason the prosecution couldn't start within 5 years was because of the defendant's wrongdoing, his misconduct, his own criminal activity of fleeing to avoid prosecution. So under those circumstances, the courts have ruled in the past, there's precedent on this, that no. The statute of limitations pauses, it tolls, it stops. During that period of time, a defendant is not being prosecuted because of his own misconduct. I argue that the same would be true if Donald Trump corruptly dismissed his own cases once he was sworn in, and then the prosecutors tried to bring them more than 5 years later. The reason he wasn't tried was his own corrupt dismissal. Now, Brian, all of this is uncharted legal water, because we don't have any kind of precedent on any of this, but I do know what the principles are with things like forfeiture by wrongdoing, which is when you flee to avoid prosecution, and I think this would be analogous. This would be a similar situation where there would be robust arguments to the court that if Donald Trump corruptly dismissed his own case, it doesn't matter how much time passed, he should still be prosecuted.
Well, let me ask you this. Donald Trump appoints an attorney general who comes in, and in the same way that Jack Smith could choose to uncorruptly just dismiss the case today because he's abiding by the OLC memo that says you can't prosecute or indict a sitting president, Donald Trump comes in and he brings his own attorney general. His attorney general comes forward and says, by the powers vested in me to oversee my own department, I've decided that, in fact, we don't have a predicate or whatever it is to continue with this prosecution, and I'm going to dismiss that. If Donald Trump's attorney general is going to use the powers vested in him by the DOJ to dismiss that case, are you arguing that just by virtue of him doing it on behalf of his new boss, that anything he does to dismiss the case would be corrupt? Because technically he can, is what I'm trying to say.
Yeah, the devil's in the evidentiary details, and all of this would have to be litigated, and all of these facts would have to be proved or disproved. But here's the thing. My position ultimately would be that, I would make the argument if the new attorney general, who is undoubtedly going to be just as corrupt as Bill Barr in a second Trump administration, comes in and just dismisses the case, here's what I would argue. I would argue, first of all, that's the product of corruption because it was a decision not based on the law or the facts or any policy or precedent. It was based on a directive by the defendant, Donald Trump, to shit-can his own case.
We already know that there's a predicate to bring this case because he was already indicted, and the indictment was voted out by grand juries, and the cases are moving forward. So we already know that both prosecutions were well-founded.
Right. But here's my fallback position. If that didn't work, I would argue, okay, wait a minute. The OLC memo says we can't prosecute a sitting criminal president. Horrific memo, but that's what it says. But that means the OLC memo should have the effect of just pausing the prosecution such that the statute of limitations does not run. It's told. It's stopped. So, there would be multiple arguments that could be made, and it's not unusual to take a number of cascading positions in court and hoping that the judge will go with one of your arguments.
So the way that you're reading this basically is in the same way that the OLC memo says that you can't indict or prosecute a sitting president, you also can't continue with the process of that prosecution by, for example, dismissing it. That would lend itself to continuing to open up this process, to continue engage in this process. Even if it's just to dismiss it, you shouldn't be allowed to engage in the process at all. Just like you can't indict a sitting president or prosecute a sitting president, you can't dismiss that case because that is inherently part of the prosecutorial process.
Yes, that would be the product of corruption, not a product of the application of the OLC memo. At least that would be one of the arguments I would make to the judge.
Okay, well, I guess time will tell whether we're going to see Jack Smith dismiss it unto himself, which I think we're both in agreement here would be the wrong choice, or to basically release any information he has and allow Donald Trump to try and dismiss it corruptly himself, which would which the argument could be made would give pro-democracy forces the opportunity to resurrect this prosecution against him down the line. Is that all?
That is. It's dense. It's complicated. It feels like a legal breakdown law school class, but hopefully we laid it out in a way that is understandable.
Yeah. Okay. Well, we will, of course, stay on top of this. For those watching right now, if you want to follow along, please make sure to subscribe to both of our channels. I'll put them right here on the screen as we head into this uncertain period here. We do ask that you continue to stay engaged, stay involved. If you need to take a break right now, that's completely understandable, but not to give up on this fight. And we'll stay here and we'll continue to analyze this stuff and do what we can to get good information into the zeitgeist. And we hope that you will follow along and make sure to continue staying on the right side of history here. With that said, I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.